Frank Policelli is in studio right now. Good morning, sir.
Good morning.
Livid is how I described you.
Yeah, here's the thing.
Yeah. And let's start, but this is about these reforms that have just been passed through the New York State Legislature. There was a press conference. Clearly, Sheriff Maciel is upset about a lot of stuff, the mugshots, and other issues like cash bail, etc. Senator Griffo said this is the Bill of Rights. We're witnessing the Bill of Rights for criminals.
Okay. I have been a member of the New York State Association of Criminal Defense Lawyers for over 30 years.
Mm-hmm.
I sat on the board from 1993 to 2000, as well as the National Association of Criminal Defense Lawyers. These reforms basically catch up to the way the federal system has been working for the last 35 years. So
you think we were antiquated?
Well, here's the thing. It's been recognized. You talk about the scales of justice being balanced. Well, you needed reform in the criminal justice system in New York State because it really didn't work the way it is now. Let me give you some examples, okay? You talk about the Bill of Rights. Well, first of all, the Bill of Rights applies to everybody and not just criminals, okay? And the thing that
I think Griffo was trying to be a little funny.
Well, the thing that gets me is that Senator Griffo seems to believe everybody's guilty, will just arrest somebody and they're guilty, and he doesn't get the other side of the story. He never talked to anybody from the NYSA CDL, New York State Association of Criminal Defense Lawyers. He never talks to defense lawyers. So, he gets up there and he makes these statements to look, I suppose, to appeal to whatever political base he has. But the bottom line is...
We don't know for sure that he hasn't spoken to a defense attorney.
Well, if he did, he didn't talk to anybody that knows what they're talking about because this is ridiculous.
Let's break it down. So,
bail.
Well,
let me do it this way.
All
okay?
right. You listen, this is your show.
The Bill of Rights, the Bill of Rights gives you the right to bail.
Mm-hmm.
It gives you the right to a fair trial, and it gives you the right to effective assistance of counsel. Okay.
Right.
So, in the current system in New York State, and the way these, by the way, this new legislation where it talks about discovery. Let me give you an example. This is the best way I could do it from a practical point of view.
This is something that hasn't got a lot of press, the discovery portion of this.
Right. Well, this is the thing that gets me the most because that's the most important to me as a defense lawyer. Under the new statute, you get discovery after a felony complaint has been filed within 15 days, okay? Why is that important? It's important because the prosecutor must announce and comply with the new discovery, to announce they're ready for trial within 6 months from the filing of the felony complaint.
Okay.
Which means basically they have to go to a grand jury and get their indictment. Well, when they go to a grand jury, they'll give a notice to the defense lawyer that your client can come to the grand jury and testify. So now from a defense lawyer's point of view, you sit down with the client and you don't know what to tell him, whether he should go or she should go in front of a grand jury because you've got no discovery.
Right. You don't know what they have on it.
You don't know what they got. So you're going to get ambushed, okay? And here's the thing. I had a case not too long ago where the prosecutor says, well, here's some incriminating evidence against your client. But they hold back on exculpatory evidence. So how could you tell your client, go to the grand jury, because you don't know what they got?
And prior to this legislation, they were able to withhold a lot of information.
Well, here's what happens. Under the prior legislation, you have a right to discovery within you make your discovery demand, they're supposed to provide you with discovery.
Yeah.
Now, here's the thing. You also have in county court, you have to be able to go through your discovery and know what motions to bring. And and then you'll go to court and the judge will say, well, here's the offer. You're going to take it or leave it. Well, I can't take it or leave it because I don't know what they got. How could I effectively advise my client? So what's happened over the years is plea bargains are struck, defendants plead guilty, they go to jail, then they find out, well, geez, if I had known this, I never would have pled guilty. Now you go back to court and you say, my lawyer was ineffective.
Right.
Okay? So you increase post-conviction litigation.
Do you feel that, so this legislation, do you feel fixes that satisfactorily?
It certainly goes in the
satisfactory to you?
It certainly goes in the right direction.
Yeah.
So that, because now if you've got your discovery and you're able to assess the case, suppose there's a search warrant. And traditionally speaking, they'll say, we'll give you the search warrant, but we won't give you the application for the search warrant. Well, what good is that? You know,
right.
How do I know if there was probable cause? How do I know if the police officer lied to the judge to get his warrant? You got to give me those papers. Now they come back and they'll say, well, you know, we got to be careful. We don't want to reveal the confidential informant. Your client is going to know this, and he may be dangerous. Listen, we've handled that 35 years ago. Judge Leslie Crocker Snyder came up with a solution to that, which is a 4-step process that you use in a search warrant application. If you're going to if there's something there that you think is dangerous, you go to a judge and redact it.
Right. Okay.
If you're afraid that somebody may be in jeopardy, go get a protective order from a judge. But to deny the lawyer the opportunity to defend his client because you're not giving him discovery, you make the lawyer ineffective per se.
Fair enough. What do you think about the no cash bail?
They've been doing that in federal court for 35 years.
Why is that advantageous to the general public? Because right now the DA, I haven't seen the DA, but certainly Griffo and the sheriff saying that this really puts the public at risk.
Well, that's ridiculous. If you read the statute, you would see all the exceptions to that. And, you know, in federal court, what they do is this. You have a detention hearing. If you are a danger to the community or a risk of flight, you get detained.
All right.
If you're not, you're released on pretrial services, and you're supervised, and there's conditions. And if you read the statute, there's several offenses.
But who gets to make that decision
the bail
now?
will still apply to. A judge makes that decision.
Well, not really, because it's the police officer, isn't it? Because when you're on the scene, you get to decide whether you give that person an appearance ticket or you bring them in. How does that work?
Well, because first of all, the appearance tickets is only applied to misdemeanors and felonies that are nonviolent. Okay, so you're not talking about any serious crimes here. All right, and if the person and if you think that the person is a risk, you go get an order of protection.
Okay,
there's remedies. This is why I'm saying if you read the article in the paper that appeared, and if you actually read the statute, all of their fears are taken care of in the statute.
It's funny because Bob Freeman yesterday did say freedom of information. We were speaking with him on all of these topics, but did say that he feels that this legislation has been misrepresented in the media, that they left parts out, and what you're saying.
Absolutely.
What about mugshots?
Well, I heard what Mr. Freeman said yesterday, and that's a case-by-case analysis, okay, where, you know, the release of that, I'm not going to get into that because that's something that, you know, is not as important to me as the discovery things.
Has cash bail been used inappropriately in some cases, been in your experience? Large cash bails posted that you just don't feel is fair?
Well, sure.
Yeah.
Well, sure. You know, the whole, you know, this is why they don't do that in federal court anymore.
But they still can on a case-by-case, depending on the case, you can still issue a bail?
Yes, and it's right here in the statute. If it's a serious crime, if it's a crime of violence, if it's a sex offense crime, you know. The problem that I have with Senator Griffo's approach is they give no respect to the presumption of innocence. They think everybody that's charged is guilty. I mean, look at some of the things he says. When in the paper, when you talk about less concern for the victims, who's talking about less concern for the victims? Where do you see that in the statute? Yeah. As a matter of fact, there is concern for the victims. Constraining our police officers. How's the police officer constrained? That's not in there. And on the other hand, putting the initiatives in place that really benefit the criminal. So everybody's a criminal. What about if you're innocent? Does he ever think about that?
Right, right.
I mean,
which is what the law is supposed to. You're innocent until you're proven to be guilty.
Well, of course.
Yeah.
And you know, and I can understand the prosecutor's concerns about giving discovery. Under the new discovery statute, you've got to give witness statements. You've got to give grand jury testimony. Well, you got to give grand jury testimony anyway under the Rosario rule before trial. So you're going to know what's against you. But the interesting thing here that was in here from Mike Kaluza is that talking about discovery, which will
I know
talks
you're
about
trying to
that
find
will
it
be
there.
used against them in court ahead of the court date. So what is he saying? Dump all the discovery and Rosario material on the defense lawyer the day before trial, and you're supposed to get ready? I mean, who's got the advantage there?
And you're saying that this is really about advantages,
It's
leveling
about,
the playing
Of course,
field.
you want you have a right to a fair trial under the Constitution. You have a right to effective representation to a lawyer under the Constitution. You have a right to bail under the Constitution.
Now, chances are that this leveling of the playing field could benefit someone who is a real criminal.
No.
You don't feel that
How
way.
you see that?
I'm throwing it out there.
No. What you do, this is another thing, because the prosecutors, look, we have an adversarial system. So they really believe everybody they prosecute is guilty or they wouldn't be prosecuting them, right? Okay. But you see, the problem is this. When you never get both sides of the debate, you get so used to thinking, well, everybody's guilty. Let's treat all of them the same as though they're guilty. I mean, when Kaluza says things like having their personal information, their statements made available to an offender. How do you know he's an offender? You haven't had a trial yet.
Right.
Yeah, you're right. How do you know he's an offender? He hasn't had a trial yet. But doesn't this, I mean, let's go back to the 60s and 70s when, and I know I'm kind of going off in a left field here a little bit, but where people would, you're going to snitch on me, you're going to rat on me,
let's go back
to
the 60s and 70s when I used to defend organized crime cases in federal court, okay?
Yep.
You had the witness protection program. You have the ability to redact statements. You have the ability, but eventually you have the right to confront your accuser under the Sixth Amendment.
Sure, absolutely.
So eventually you're going to do that. You have to know what you're up against if you're going to have a fair trial. You cannot say, and if you think that somebody is going to intimidate somebody, you better have some proof to say that and go to a judge and have a judge make that decision. You cannot assume everybody is guilty, everybody's bad just because you charged them.
Fair enough. So that because really the what we're hearing in the media is all kind of one-sided. It is Griffo, it's Sheriff Mashel, all saying that this does put a disadvantage on law enforcement and on the prosecution.
I can understand the sheriff taking that he's law enforcement. He's not a lawyer.
Right.
Okay.
Right.
I'm disappointed in a politician who's supposed to represent everybody and support the Constitution taking that approach. I mean, if he thinks it's politically expedient, more power to him. I
would suggest he probably believes what he said. He believes this is not.
That's even more dangerous.
Okay, I'll let you leave it at that. Frank Policelli. Interesting.
The other thing. Let me bring this up. Okay. You talk about the presumption of innocence. How many people presume Trump to be innocent when you listen to programs like MSNBC and the like? Okay?
You're going down this road.
Well, everybody. This is what I'm saying.
Right.
Whether you like a person or not doesn't matter under the criminal justice system. Everybody has to be protected by the Constitution, and everybody is entitled to the protection of the Bill of Rights.
Right. Fair enough. Frank Policelli, we appreciate it. It's always awesome when you come in. I appreciate it. Great.
Okay. Thank you.
Because you hold back so much. It's 7:30. We'll do the free money question coming up. Joe Marino claims the video that was posted and given to the investigator has about 45 seconds taken out of it.
Do you have any thoughts on this? Can I ask that?
You can?
Are you familiar?
You don't
with
really
this?
know anything about it.
The argument in the council chambers, was it physical? What happened? There was a video of it. We got word this morning that the video, according to Joe Marino, who is the subject of part of this investigation,
he sent a letter to McNamara complaining about it.
He's basically saying that the video that was given, the video of the alleged incident, is missing 45. There's a 45-second clip
in the middle.
How would you handle that in a courtroom? You'd call for an immediate dismissal, wouldn't you?
Well, who knows? I'd have to look at it. I'd have to study. See, this is the thing. When you get discovery, you just don't read it and make a snap decision.
I do.
Well,
it at least levels the playing field. So the ultimately your client, whether really guilty or not, your client is given an opportunity to defend him or herself.
Yeah, you got to do your job.
Interesting, Mr. Policelli. Thank you so much.